computer. Peace, love, and prosperity to all of the human family out here in the world. AMPAG Moxon is back with part 2 of France versus United States, the case concerning the rights of nationals in the United States of America inside of the land of Morocco. So whenever there's a question as to whether this is Morocco or not, go read the title. Oh, and by the way, there's other treaties that back up the notion that this is Morocco. There's no question about it. So we ended up at page 15. And so we'll begin there. Maybe, I don't know, I'm not sure. I don't think we'll be able to cover it all, but we'll surely try. If anyone has any questions, just interrupt me and let's ask our questions and we'll keep it going from there. So as it goes, it is common ground between the parties that the present dispute is limited to the French zone of Morocco. It is on this ground that it has been argued. The court cannot, therefore, pronounce upon the legal situation in other parts of Morocco. In order to consider the extent of the rights of the United States relating to consular jurisdiction, it has been necessary to examine 3 groups of treaties. What treaties are they examining? The first group includes the bilateral treaties of Morocco with France, the Netherlands, Great Britain, Denmark, Spain, the United States, Sardinia, Austria, Belgium, and Germany, which cover the period from 1631 to 1892. That's a lot of, that's about 200 years, right? And from 1631, so let's say 1631, right? What was the, what's the word am I looking for? What was the appearance, let's say for lack of a better term, the racial prima facie of the people in the 1600s of, let's say, France, the Netherlands, Great Britain, Denmark, Spain, obviously, well, yeah, the United States, Sardinia, Austria, Belgium, Germany. What these people look like? In other words, I guess what I'm asking is, do you think that these people were white? Because if you do, you got some studying to do. If you're talking 1600 time frame, these were Moors. So these were French Moors, Netherlands Moors, British Moors, right? Spanish Moors. And then the United States, for example, John Hanson, right? John Hanson, he was the first president of the United States, not the United States, what was it called? Continental Congress.
Continental Congress.
Right, and he, blacker than me. So who was the United States? Is it really like colonizers? I mean, wrong term. Were they really like Caucasians type people? And the reason why I'm saying that was the wrong term to use is because a colonizer is an act, it's not a people. Moors were colonizers. They've been trying to colonize us. Genghis Khan was trying to colonize us in the 1600s when he came with the Mongolians and all that. That's how you got these Mexicans looking like they kind of like somewhat Chinese, because Genghis Khan was Chinese. He was the emperor of China, and he was dark. All the indigenous people all around the world are dark. And so who were they talking about? What people were they talking about in 1631 to around 1800s is when things starting to lighten up a little bit for the most part. But prior to that, 1600s, 1700s, what's the reference point that Beethoven was a Moor? What's the reference point? Well, he was born in 1770. We was running things at that time. These people were still in bondage on different levels, including harems, maybe not even at that point, because the harem thing was really during Spain or the Iberian Peninsula, Alhambra, before the fall. That's when the harems was really taking place. And if you don't know what a harem is, it's a concubine or whatever. So where all the Caucasian women would go please the Moorish kings and such. That's what a harem is. That's where that's who we fell to the offspring, the children that was born out of these harems. So Queen Isabella and King Ferdinand, they weren't Caucasians per se, or at all, really. They were mixed. They were like Fat Joe and J-Lo. They were like Spanish and Latinos types. They weren't like white people, you know. So was Christopher Columbus. Cristobal Colon, that's his real name, actually. It's Cristobal Colon, it's not Christopher Columbus. All right, continuing on. These treaties, which were largely concerned with commerce, including the rights and privileges of foreign traders in Morocco. These treaties, which were largely concerned with commerce, including the rights and privileges of foreign traders in Morocco, dealt with the question of consular jurisdiction in 3 different ways. 1, certain of the treaties included specific and comprehensive grants of rights of consular jurisdiction to the powers concerned, e.g., the treaties with Great Britain of 1856 and with Spain of 1799 and 1861. They slowly made their way over here after 1492. You see how long it took for them to subjugate us? From 1492 to around really like the 1700s, 1800s. You know, how many years is that? Like 400 years, 400 years? From 1492? Yeah. Took them some time to fully subjugate us. Certain of the treaties made strictly limited grants of privileges with regard to consular jurisdiction. So they've been given strict limited grants of privileges as it relates to consular jurisdiction, e.g. the treaties with the United States of 1787 and 1836. What treaty is that? Which treaties are they referring to? Somebody got to be able to answer that. The treaties with the United States of 1787 and 1836.
Peace and friendship.
Piece of friendship. Who said that so I can give you a cookie? Piece of friendship.
Fahim.
Fahim, your brother, what's going on? The second.
What's good?
Islam.
What's good, brother?
Gotta get
Islam.
back.
I like chocolate chip cookies, man. Oatmeal cookies.
I got you. I got you for sure. I got to get back with you on that October 7th date. We'll talk about that.
Okay, indeed.
All right. And then, so it says certain of the treaties made strictly limited grants of privilege, limited grants of privileges. Limited grants of privileges with regard to consular jurisdiction. So the United States, through these treaties, have limited grants of privileges with regards to consular jurisdiction. Well, if they have limited grants of privileges, who's got the full grants of privileges? The Moors, the Moroccans. That's who else, those are the 2 parties. It's between the United States and Morocco. The United States of America, I should say, and Morocco. Or it's between the Americans and the Moroccans. Why we cannot be Moorish Americans. You got to choose between the 2 jurisdictions. Which jurisdiction you want to be with or be under. America or Morocco. The cares of the world or the rock of salvation. You have your own right to self-determination, but if you decide that you want to stay within the American jurisdiction as an American citizen or national, You still can't do it until you get consent from who? Somebody answer that question. Even if a Moorish subject decided that he wanted to remain as an American citizen, he has to get consent. Who?
Sharif Empire.
From a competent Moorish government.
From a competent Moorish government.
Give me my cookie.
From Morocco, that's your cookies. Cookie Monster with the neck brace. All right, that's not funny. Number three. So I think that's understood. There were other treaties which did not define in specific terms the treaty rights granted by Morocco, but instead granted to the foreign nations through the device of most favored nation clauses, the advantages and privileges already granted or to be granted to other nations. Right? All the European signatory powers had that, were granted that clause of most favored nation clause. But what's really interesting is that the United States, or should I say, the International Court of Justice judges said that, according to the Treaty of Peace and Friendship, the United States only got limited jurisdiction, limited consular jurisdiction. Right now, they're exercising it as if that's it, right? You know, full throttle, but only because we are sleeping. So when Prophet Noble Ali said, "We're going to leave the Europeans here long enough to teach you how to run government," call me crazy, but in my personal interpretation, it sounds to me as if he wants us to run government. He wants us to establish governments and run our governments. So that being my interpretation doesn't make me a dirty Moor, right? Just because you interpret it as something else, as a temple Moor, and I interpreted it a little bit differently as just a Moor, because I'm not with the whole, I was called a treaty Moor. That's the new one. Somebody called me a treaty Moor. I'm like, oh, okay, so I'm a treaty Moor. Am I not just a Moor? Why we gotta use these labels to divide each other? While at the same time keep saying that, you know, Moors need to learn to love instead of hate. Well, why are you using terms like that? Why would you use such a divisive term such as I'm a treaty Moor? I thought I was just a Moor. You know, you got to put an adjective with it. So what other kind of Moor can I be? A church Moor, a Christian Moor, right? A synagogue Moor, an international law Moor? Like, come on, Moors, let's stop this crap, you know, and start studying. The prophet said clearly that he wants us to establish governments. And that's what we did. So we can't be going against the prophet. He also said that we must worship under our own vine and fig tree. And every nation must confess their own. What is your vine and fig tree? Your flag and seal. And how do you confess your own? Legislation. Writing laws to govern your own people and whatever foreigners that may be on your land. I mean, you know, I don't know what these people be, I don't know what they're reading, man, but the old paradigm is rooted, is deeply rooted. 3, there were other treaties which did not define in specific terms the treaty rights granted by Morocco, but instead granted to the foreign nations through the device of most favored nation clauses. The advantage and privilege is already granted or to be granted to their nations. There is a common element to be found in the most favored nation clauses, which have brought about and maintained a situation in which there could be no discrimination as between any of the powers in Morocco. So all those powers that I just mentioned, all those powers that's in the Treaty of Madrid, all those powers that's in the Act of Algeciras are in Morocco.
Islam, point of interest.
Go ahead.
Do you know which was the first treaty with Morocco in 1631?
No.
It was the Franco and Moroccan treaty.
It was the what?
Franco-Moroccan.
That was the Franco-Moroccan treaty.
Yeah, 1631 is the first one. So, and I'm bringing it up because they keep talking about the most favorite nation, and we always see France in the mix when they're talking about the most favorite nation a lot of times. And I think that that could be something of why they're like one of the most favorite nations, because they were one of the original nations to have a treaty with Morocco.
Right, right. And that's not the last one. Because that's a bilateral treaty, right? Just between France.
Yeah, it was a
Morocco.
bilateral. Mhm.
Right. But then they're also part of multilateral treaties, right? They're part of the Treaty of Madrid and the Treaty the Act of Algeciras. But then they also have another bilateral treaty that came out in 1912. What's that? Treaty of Fez.
Treaty of Fez.
You know, the protectorate in the French zone in Morocco. So it says here that the signatory powers are in Morocco. So that means that Spain is in Morocco. That means that Great Britain is in Morocco. I mean, let's read it again just to verify who said it, because it wasn't me. All right. There is a common element, and it's a common element too, by the way. There is a common element to be found in the most favored nation clauses which have brought about and maintain a situation in which there could be no discrimination as between any of the powers in Morocco, regardless of specific grants of treaty rights. Germany. So Morocco so it's North Central South America, the islands, Europe, Africa, the whole world. It's in Russia. It's in chapter 47 of the Holy Circle 7 Holy, the Holy Seven Circle Quran, the Circle 7 Holy Quran. It's in chapter 47. If you're gonna give a label to me as a Moor, don't call me a Temple Moor, don't call me a Treaty Moor, don't call me that. You can call me a Juali Moor. I'll take that. Because if it wasn't for the great prophet Noble Juali, there wouldn't be no AMPAG, there wouldn't be no Moors, there wouldn't be no Moorish flag to know of, or fezzes and turbans, or days and bays and Ali, none of that. We'll be in darkness. We were brought into marvelous light. And so I just on the strength of that alone, I must honor the prophet, man. I can't, it'd be foolish of me to go against that. And it could be a curse too. There's some people out there cursed for all the dirty things they've attempted to say about Prophet Noble Ali. But that's another story. These powers are in Morocco. And where do we learn the science of this being Morocco and the present Moroccan Empire? Prophet Noble Ali, chapter 47. Regardless of specific grants of treaty rights, when the most extensive privileges as regards consular jurisdiction were granted by Morocco to Great Britain in 1856, right? When the most extensive privileges, so Great Britain got the most extensive privileges as regards consular jurisdiction were granted by Morocco. It was granted by Morocco to Great Britain in 1856. See, at this time, 1856, they start lightening up the Arabs, the light-skinned Arabs, they're starting lightening up at this point. But 1856 ain't too far from 1880. What came out in 1880? The right of protection in Morocco, Treaty of Madrid. Were granted by Morocco to Great Britain in 1856 and to Spain in 1861. So Great Britain and Spain got that privilege. These inured automatically and immediately to the benefit of the other powers by virtue of the operation of the most favored nation clauses. The second group consisted of multilateral treaties, the Madrid Convention of 1880 and the Act of Algeciras of 1906. The method of relying on individual action by interested powers equalized by the operation of the most favored nation clauses had led to abuse and it had become necessary not merely to ensure economic liberty without discrimination, but also to impose an element of restraint upon the powers, but also to impose an element of restraint upon the powers and to make steps or to take steps to render possible the development of Morocco into a modern state. Uppercase S, by the way. And that was the other point, Brother Hakeem. Whenever we refer to AMPAG as a state, we use the word state, it goes in upper caps. United States is with lower caps, because or specifically the state of. But you can do that with the United States as well, because they're not an organic state by international law. When you're dealing with organic states, they come in the S is spelled with an uppercase. But I don't know. For some reason, I feel compelled to read this again. The method of relying on individual action by interested powers, equalized by the operation of the most favored nation clauses, had led to abuse, and it had become necessary not merely to ensure economic liberty without discrimination, but also to impose an element of restraint upon the powers and to take steps to render possible the development of Morocco into a modern state. I didn't say that. And when it says restraint, an element of restraint upon the powers, who are the powers? The signatory powers. Who are the signatory powers? The Christian powers, the European nations. France, Great Britain, Spain, Germany, etc. Sweden. By the way, the International Bank of Settlements, which is the biggest bank in the world, is in Sweden. No, or New Zealand. I think it's Sweden. It still belongs to us. That's the point. Accordingly, the point is to establish or develop Morocco into a modern state. Who has taken those steps? I don't know. Let's see. AMPAG, New Mecca, and AMPAG. Accordingly, the rights of protection were restricted, and some of the limitations on the powers of the Sultan as regards foreigners, which had resulted from the provisions of the earlier bilateral treaties, were abated. The possibility of abuse in the exercise by Morocco of the powers thus extended was taken care of by reserving an element of supervision and control in the diplomatic body at Tangiers. The third group of treaties concerned the establishment of the protectorate. It included the agreements which preceded the assumption by France of a protectorate over Morocco and the Treaty of Fez of 1912. Under this treaty, Morocco remained a sovereign state, but it made an arrangement of a contractual character whereby France undertook to exercise certain sovereign powers in the name and on behalf of Morocco, right? France undertook to exercise certain sovereign powers in the name and on behalf of Morocco. Power of attorney, they were granted that power, and in principle, all of the international relations of Morocco. France, in the exercise of this function, is bound not only by the provisions of the Treaty of Fez, but also by all treaty obligations to which Morocco had been subject before the protectorate, and which have not since been terminated or suspended by arrangement with the interested states. So in other words, it's still in force. That's why when we say that AMPAG is or AMPAG or whatever, New Mecca, is a provisional state under the existing and pre-existing sovereignty of the Empire of Morocco or authority of the Empire of Morocco, as if Morocco still exists. It does. What? On paper, through what? Treaties. The treaties are still in force, and the treaties is with Morocco, and the whole point is to develop Morocco into a what? Modern state. I mean, it's in the documents, man. It's not something that we're making up here. It's like, you can't debate me. You can't argue with me, because debating me and arguing with me is arguing with the Sultan and the treaties and the judges. that's my reference points. But I'm reading it right here. The establishment of the protectorate was the treaties. Accordingly, France initiated negotiate. Hold on. I got past my point. What was I? The establishment of the protectorate and the organization of the tribunals of the protectorate, which guarantee judicial equality of foreigners, brought about a situation essentially different from that which had led to the establishment of consular jurisdiction under the earlier treaties. Accordingly, France initiated negotiations designed to bring about the renunciation of the regime of capitulations by the powers exercising consular jurisdiction in the French zone. In the case of all the powers except the United States, these negotiations led to a renunciation of capitulatory rights and privileges, which, in the case of Great Britain, was embodied in the Convention of July 29, 1937. In the case of the United States, there has been negotiation throughout which the United States had reserved its treaty rights. So this is saying that France went into negotiation with the other powers to pull out of Morocco, to relinquish their jurisdiction, their consular jurisdiction, capitulatory rights and privileges. Right, so let's keep reading and see what happened. The French submission is based upon the treaty between the United States and Morocco of September 16, 1836. So the French submission is based upon the treaty between the United States and Morocco. Think about what I just read. The French submission is based upon the treaty between the United States and Morocco. In other words, what the hell y'all got to do with this? How is France using Moroccan law treaty provisions for their defense? They're using the treaty between two other states to, for their, for their case, for their argument. And the United States is doing the same. So France is using Moroccan law for their argument, and so is the United States. Wow. And where are the Moors? Twerking, undertaking individual processes, writs and affidavits with the United States flag on it, claiming, or really rejecting their jurisdiction while claiming their jurisdiction at the same time. Now that's a trick bag when you sitting here rejecting the jurisdiction while at the same time accepting it, and you don't even realize that you're accepting it. I'm not a citizen. I'm a Moorish American. Okay. Did you just hear yourself? And you reinforce that with your writs and affidavits that has the United States flag on it. We got to study international law. They're telling us everything. The French submission is based upon the treaty between the United States and Morocco of September 16, 1836, and it is common ground between the parties that the United States is entitled to exercise consular jurisdiction in the case of disputes arising between citizens or proteges. Who are the proteges? The Moors, the Moroccan subjects and proteges. There is therefore no doubt as to the existence of consular jurisdiction in this case. The only question to be decided is the extent of that jurisdiction in the year 1950 when the application was filed. Right, so let's read that again. We got a clear understanding. The French submission is based upon the treaty between the United States and Morocco of September 16th, 1836. And it is common ground between the parties that the United States is entitled to exercise consular jurisdiction in the case of disputes arising between its citizens or proteges. Well, why is the United States entitled to exercise consular jurisdiction? Can someone answer that? Can you answer that, Charlemagne? Why is the United States entitled to exercise consular jurisdiction in the case of disputes arising between citizens and proteges, or citizens or proteges? The reason why is because somebody's about to say something. Okay, the reason why is because there was no more states available to exercise consular jurisdiction. So by default, the other signatory power took over. In this case, it was the United States. But if Morocco was in full effect, then the United States would still be in a subordinate position. Simple. That's why we need to wake back up to our state governments. The first point raised by the submission related to the scope of the jurisdictional clauses of the Treaty of 1836, which reads as follows. Article 20. Let's read that. If any of the citizens of the United States or any persons under their protection shall have any dispute with each other, where is it at? The consul shall decide between the parties, and whenever the consul shall require any aid or assistance from our, keeping in mind that it was the Moroccan Moxons that wrote this, our government, to enforce his decision, it shall be immediately granted to him. Right? And then Article 21. If a citizen of the United States, now this case is res judicata, right? And it was adjudicated by highly competent judges. The highest, tell me a higher judge and an ICJ judge, other than maybe an ICC judge, right? These are international judges. These aren't United States municipal law type judges. And they're quoting Article 21. But what's the language that's in Article 21? Who are the parties that are being identified in Article 21? Who are the parties that are being identified in Article 21? Well, let's find out. If a citizen of the United States should kill or wound a Moor. So they know who the Moors are. And they know that the Moors are in Morocco, subjugated as Moorish subjects under American jurisdiction. So the Moroccans are subjugated on their own land, which is called Morocco, and they're under American jurisdiction as Moorish subjects. That's what's going on. They didn't come from Africa. They didn't come from Africa on the slave ships as slaves, and they're in Morocco. Therefore, they're Moroccans. You're not a descendant of Moroccans born in America, and then therefore suddenly now you're just something else. But the reason why that was being said is because you was born in America. How? Because you was naturalized adopted into the foreign jurisdiction against your consent. And even worse, against the Moroccan government consent. But they know who we are. They're calling out Article 21, and it's telling you who is who right there. The two parties. Who are the two parties? Citizens of the United States and Moors. If a citizen of the United States should kill or wound a Moor, or on the contrary, if a Moor, two is twice, is in there twice, shall kill or wound a citizen of the United States. So who are the two parties? Moors and United States citizens. That's it. So a United States citizen can also be a Moorish subject, branded as Negro, blacks, colored, African American, Moorish American, Aboriginal, indigenous, all that. Because you're not an Aboriginal and indigenous to America. You're Aboriginal and indigenous to Morocco. Come on, Moors. Let's get out of this trick bag. We got to get out of this trick bag. We have to. That trick bag is a big setback. Can't keep calling ourselves Americans. Like really believing at the same time and like just, standing, we're American. No, we're not Americans. In this land, the name of that name is not ancient on this land. I mean, the prophet said that the Moorish flag was flying on this land over 10,000 years. Surely he wasn't talking about red, white, and blue banner. He was talking about the Moroccan flag. So 10,000 years ago, was this called America? No, it was called Morocco. So then that means that America is not an indigenous, Aboriginal or indigenous nothing. What's Aboriginal and indigenous and ancient is Morocco. And therefore we are Moroccans. Or Moors. Morocco, Moroccan, Moor. When the prophet was standing on the rock, when he was stepping out of the cares of the world, i.e. America, onto the rock of salvation, carrying the mother, he was stepping on the rock of salvation. I challenge you to spell Morocco without the word rock. You gotta spell rock. You gotta say, when you say Morocco, you gotta say rock. Morocco. The prophet was stepping on the Morocco of salvation. The prophet was brilliant. He said it's gonna take 1,000 years for y'all to catch it. He didn't say 1,000, he said what, 100 years? It's gonna be 100 years before y'all catch on to what I've brought you. It's just beautiful. He stepped out of the cares of the world, amity of the amity law, law of the, what is it called? Amity, law of amity and commerce. Not even maritime law, amity. Maritime is the sea. Civil law, common law is the land. Amity law deals with the water coming onto the land. That's where you get your UCCs and all that. You're coming out of being lost at sea. The cares of the world. The cares of the world is being imposed on all of humanity by America. The jurisdiction of the American, the foreign jurisdiction called America, United States of America, the United States Federal Corporation, and its several chartered colonies that have never ratified and deposited their constitution according to international law, by the way. If a citizen of the United States should kill or wound a Moor, or on the contrary, if a Moor shall kill or wound a citizen of the United States, the law of the country shall take place, and equal justice shall be rendered, the consul assisting at the trial. And if any delinquent shall make his escape, the consul shall not be answerable for him in any manner whatever. Right? So you're just gonna send out the the marshals after him for trying to make his escape. But at the end of the day, the consul has the final decision. And that's what they're pointing out on Article 20 and Article 21. But I'm just going deeper with the whole idea that Article 21 has the word more in there. And then also citizens. So the treaties between the United States of America and the Sultan of Morocco or Morocco, the Americans and the Moroccans, the United States citizens and the Moors. Come on, y'all. This is actually elementary. It's not even really nothing to discuss. You know, I'm gonna get this on VH. I'm gonna get this on VHS and send it to certain people so maybe they'll get the point if I do that. It is argued that Article 20 should be construed as giving consular jurisdiction over all disputes, civil and criminal, between United States citizens and proteges. Let me read that again. It is argued that Article 20 should be construed as giving consular jurisdiction over all disputes, civil and criminal, between United States citizens and proteges. France, on the other hand, contends that the word dispute is limited to civil cases. It has been argued that this word in its ordinary and natural sense will be confined to civil disputes, and that crimes are offenses against the state and not disputes between private individuals. All right, so y'all keep on with this Moorish American. I'm an individual trying to invoke Article 20 of the Treaty on Peace and Friendship. The Treaty of 1836 replaced an earlier treaty between the United States and Morocco, which was concluded in 1787. The two parties were substantially identical. The two treaties were substantially identical in terms, and Articles 20 and 21 are the same in both. Accordingly, in construing the provisions of Article 20, and in particular, the expression shall have any dispute with each other, it is necessary to take into account the meaning of the word dispute at the times when the two parties were concluded, the two treaties, why I keep saying parties, at the time that the two treaties were concluded. For this purpose, it is possible to look at the way in which the word dispute or its French counterpart was used in the different treaties concluded by Morocco, e.g. with France in 1631 and 1682, with Great Britain in 1721, 1750, 1751, 1760, and 1801. There's a lot of treaties. It is clear that in these instances, the word was used to cover both civil and criminal disputes. It is also necessary to take into account that at the times of these two treaties, the clear-cut distinction between civil and criminal matters had not yet been developed in Morocco. Accordingly, it is necessary to construe the word dispute as used in Article 20 as referring both to civil disputes and to criminal disputes, insofar as they relate to breaches of the criminal law committed by a United States citizen or proteges. You see, so it don't say protege in the treaty. It don't say true. That's not what it says in the treaty. Article 21 don't say nothing about no protege. It says Moors. It says United States citizens, and then it also says Moors. But here it says protege. So they're attributing terms like subjects, proteges, Moors, Moroccans, Moroccan subjects. These terms are being attributed to us. We are the proteges, we are the Moors, et cetera, et cetera. The reason why in the treaty it said Moors is because we wasn't our proper person at that time, or more so than now, or at least in the 1950s. By the 1950s, we didn't reduce that. We didn't went from Moors to proteges. Internationally, within the jurisdiction of America, we became Negroes, Blacks, Coloreds, and everything else, African Americans and Moorish Americans. The second point arises out of the United States submission that consular jurisdiction was acquired in all cases in which an American citizen or protege was defended through the effect of the most favored nation clause and through custom and usage, and that such jurisdiction was not affected by the surrender by Great Britain in 1937 of its rights of jurisdiction in the French zone, and has never been renounced expressly or impliedly by the United States. So Great Britain had surrendered its jurisdiction in Morocco in 1937. It is necessary to give special attention to the most favored nation clauses of the United States Treaty of 1836. There were two grants of most favored nation treatment. Article 14 provides, the commerce with the United States shall be on the same footing as in the commerce with Spain, or as that with the most favored nation for the time being, and their citizens shall be respected and esteemed and have full liberty to pass and repass our country. This is Morris talking, Moroccans, and seaports whenever they please without interruption. So that's a privilege that was extended to them as through the most favored nation clause. Article 24 deals with the contingencies of war, but it contains a final sentence. And it is further declared that whatever indulgence in trade or otherwise shall be granted to any of the Christian powers, the citizens of the United States shall be equally entitled to them. So, the Sultan gave him some limited, they gave him the treaty rights, gives them the whole nation, favored nation clause, right? But let's continue reading and see what else happens from there. These articles entitle the United States to invoke the provisions of other treaties relating to the capitulatory regime. The most extensive privilege in the matter of consular jurisdiction granted by Morocco were those which were contained in the General Treaty with Great Britain of 1856 and in the Treaty of Commerce and Navigation with Spain of 1861. Under the provisions of Article 9 of the British Treaty, there was a grant of consular jurisdiction in all cases, civil and criminal, when British nationals were defendants. Similarly, in Articles 9, 10, and 11 of the Spanish Treaty of 1861, civil and criminal jurisdiction was established for cases in which Spanish nationals were defendants. I bet you them Spanish nationals were pretty dark. Accordingly, the United States acquired, by virtue of the most favored nation clauses, civil and criminal consular jurisdiction in all cases in which United States nationals were defendants. The controversy between the parties with regard to consular jurisdiction results from the renunciation of capitulatory rights and privileges by Spain in 1914. So Great Britain was in 1937 and Spain was in 1914. The renunciation by Spain in 1914 had no immediate effect upon the United States position because it was still possible to invoke the provisions of the General Treaty with Great Britain of 1856. These are things that should be read and discussed and studied in the temples. Somebody mute your mic, please. Somebody mute your mic, please.
Oh, his mom. I'll get him.
Somebody mute your mic, please. I guess
Islam, you should be able to mute him as
no,
host.
but I can't see them from the. Let me see. Let me do this.
It's Frank.
Is who?
Frank.
Frank. Well, Franklin. Okay, it stopped. I don't be wanting to do that to people. All right, the controversy between the parties with regard to consular jurisdiction results from the. Did I already read that? Yeah. Okay, so I was down here. So it says, where is it? So the treaty with Great Britain in after 1937, however, no power other than the United States has exercised consular jurisdiction in the French zone of Morocco, and none has been entitled to exercise such jurisdiction. So everybody done pulled out, right, by what, 1837? France contends that from the date of the renunciation of the right of consular jurisdiction by Great Britain, the United States has not been entitled either through the operation of the most favored nation clauses of the Treaty of 1836 or by virtue of the provisions of any other treaty to exercise consular jurisdiction. France said, y'all ain't got no treaty rights on this one, beyond those cases which are covered by the provisions of Articles 20 and 21 of the Treaty of 1836. The United States submission is based upon a series of contentions which must be dealt with in turn. The first contention is based upon Article 17 of the Madrid Convention of 1880, which reads as follows: the right to the treatment of the most favored nation is recognized by Morocco as belonging to all the powers represented at the Madrid Conference. Even if it could be assumed that Article 17 operated as a general grant of most favored nation rights to the United States and was not confined to the matters dealt with in the Madrid Convention, it would not follow that the United States is entitled to continue to invoke the provisions of the British and Spanish treaties after they have ceased to be operative as between Morocco and the two countries in question. So if they had still been exercising that clause, then the United States would be able to still continue exercising that clause. But because they have relinquished consular jurisdiction, the United States is left in the cold. Like, they can't really use that as a proper defense, that they have the right to most favored nation clause. This is interesting. The contention of the United States is based upon the view that most favored nation clauses contained in treaties with countries like Morocco must be given a different construction from that which is accorded to similar clauses in treaties with other countries. Two special considerations need to be taken into account. The first consideration depends upon the principle of a personal law and the history of the old conflict between two concepts of law and jurisdiction, the one based upon persons and the other upon territory. The right of consular jurisdiction was designed to provide for a situation in which Moroccan law was essentially personal in character and could not be applied to foreigners. The second consideration was based on the view that the most favored nation clauses in treaties made with countries like Morocco should be regarded as a form of drafting by reference rather than as a method for the establishment and maintenance of equality of treatment without discrimination amongst the various countries concerned. According to this view, rights or privileges which a country was entitled to invoke by virtue of a most favored nation clause and which were in existence at the date of its coming into force would be incorporated permanently by reference and enjoyed and exercised even after the abrogation of the treaty provisions from which they had been derived. So from either point of view, this contention is inconsistent with the intentions of the parties to the treaties now in question. This is known both by the wording of the particular treaties and by the general treaty pattern, which emerges from an examination of the treaties made by Morocco with France, the Netherlands, Great Britain, Denmark, Spain, United States, Sardinia, Austria, Belgium, and Germany over the period from 1631 to 1892. These treaties show that the intention of the most favored nation clauses was to establish and to maintain at all times fundamental equality without discrimination among all of the countries concerned. Further, the provisions of Article 17 of the Madrid Convention, regardless of their scope, were clearly based on the maintenance of equality. So everybody got the same favorite nation clause because it's based on equality. Can't give it to one and not the other. Everything was operating in like manner. So if you got 10 signatory powers to a treaty, I can't say, okay, well, you got, you can't discriminate, right? So if one gets the most favored clause, then all of them do. That's what I'm reading there. The contention would therefore run contrary to the principle of equality, and it would perpetuate discrimination. It cannot support the submission of the United States regarding the extent of the consular jurisdiction in the French zone. The second contention of the United States is based upon the geographically limited character of the renunciation of consular jurisdiction by Great Britain. This was restricted in its scope to the French zone. It has been claimed on behalf of the United States that Great Britain retained its jurisdictional rights in the Spanish zone, and it has been argued that the United States, which still treats Morocco as a single country, is entitled under the most favored nation clause in Article 24 of its treaty to the same jurisdictional rights which Great Britain today exercises in a part of Morocco by virtue of the Treaty of 1856, parts of Morocco. So it's like, the islands. Let me look something up real quick to add to the discussion, because it just came. Go to Google. There's a map. So you got Spanish zone, French zone. Images. Now I know the map when I see it. I hope I see it. Because it tells you, well, it's giving you, that's not, okay. Let's say instead, Spanish zone and French zone in US.
Point of interest. Is it the map you're looking for before the Louisiana purchase?
Yeah, I think that's what it is. Right here, I think. You guys can see that? Here on the right? North America, 1700. New France is up here. And this is New Spain over here. Can you all see that? Hello?
Islam?
Can you all see this? Can y'all see the map? I want to make sure everybody can see the map.
Yeah, we see it.
Well, thank you. I appreciate it. How many times I've got asked?
Islam, we said, brother, we
Just picking
said.
up the
Yeah,
map.
I just wanted to verify because I've been having problems with all that. So you see this one here, it says Nueva España, that means New Spain. Nueva Castilla and Nueva Mauricia. But this is the main one right here, the French zone, and then the Spanish zone. So these are the zones that they're talking about. And then right here you had the 13 colonies. Follow? That gives a better picture as to what they're talking about. Okay. All right. It has been claimed. Okay, I've already read that. So the court is not called upon to determine the existence or extent of the jurisdictional rights of Great Britain in the Spanish zone. It is sufficient to reject this argument on the ground that it would lead to a position in which the United States was entitled to exercise consular jurisdiction in the French zone, notwithstanding the loss of this right by Great Britain. The result would be contrary to the intention of the most favored nation clauses to establish and maintain at all times fundamental equality without discrimination as between the countries concerned. Reliance has also been placed upon the position of France and French nationals as regards the new tribunals of the protectorate, which have been established for the purpose of exercising jurisdiction over foreigners and applying Moroccan laws to them in the French zone. These tribunals have been constituted with French, have been constituted with French aid and under French direction and supervision. It is suggested that there are, in reality, consular courts, and that the United States is entitled to be placed in this regard in a position of equality with France. But the tribunals of the protectorate in the French zone are not in any sense consular courts. They are Moroccan courts, organized on French models and standards, affording guarantees of judicial equality to foreigners. Accordingly, the court cannot accept this contention. We go back up. In other words, they're saying that's those. But the tribunals of the protectorate in the French zone are not in any sense consular court. Why? Why is it not consular court? They are Moroccan courts, organized on French models and standards, affording guarantees of judicial equality to foreigners. Accordingly, the court cannot accept this contention. So it's like saying that those are Moorish courts. Moors aren't in those courts. You're over here extending and affording guarantees of equality to foreigners, and you know, it's based on French models and standards. That's not a Moroccan, that's not a Moorish court. So accordingly, the court cannot accept this contention. They kicked it out, right? The third contention of the United States is based upon the nature of the arrangements which led to the termination of Spanish consular jurisdiction in the French zone by a convention between France and Spain of November 27, 1912. Provision was made for the exercise by Spain of special rights and privileges in the Spanish zone. By a bilateral declaration between France and Spain of March 7, 1914, Spain surrendered its jurisdiction and other extraterritorial rights in the French zone, and provision was made for the subsequent surrender by France of similar rights in the Spanish zone. Right, so Spain coming out of the French zone and France coming out of the Spanish zone. This was accomplished by a bilateral declaration between France and Spain of November 7th of the same year. The United States contends that as both the Convention of 1912 and the Declaration of 1914 were agreements between France and Spain, and as Morocco was not named as a party to either agreement, the rights of Spain under, and you see what they said? They're trying to say they're standing on the fact that Morocco was not one of the parties. So the United States contends that as both the Convention of 1912 and the Declaration of 1914 were agreements between France and Spain, and as Morocco was not named as a party to either agreement, the parties must be known. So he's trying to stand on this, or they are trying to stand on their square that Morocco was not a party to the treaty or that agreement. The rights of Spain under the earlier provisions still exist de jure, notwithstanding that there may be a de facto situation which temporarily prevents their exercise. Even if this contention is accepted, the position is one in which Spain has been unable to insist on the right to exercise consular jurisdiction in the French zone since 1914. The rights which the United States would be entitled to invoke by virtue of the most favored nation clauses would therefore not include the right to exercise consular jurisdiction in the year 1950. They would be limited to the contingent right of re-establishing consular jurisdiction, right? Consular jurisdiction at some later date in the event of France and Spain abrogating the agreements made by the Convention of 1912 and the Declaration of 1914. France contends that these agreements were concluded pursuant to the power which Morocco conferred on France. France contends that these agreements were concluded pursuant to the power which Morocco conferred on France by the provisions of the Treaty of Fez of 1912. The general terms of Article 5 and 6 were broad enough to give to France the conduct of the international relations of Morocco, including the exercise of the treaty-making power. The convention and the declarations must therefore be regarded as agreements made by a protecting power within the scope of its authority, touching the affairs of and intended to bind the protected state, uppercase S, as is made clear by the third paragraph of Article 1 of the Treaty of Fez of 1912, which provided that the government of the Republic will come to an understanding with the Spanish government regarding the interests with the latter government, which the latter government has in virtue of its geographical position and territorial possessions on the Moroccan coast. In these circumstances, it is necessary to hold that these agreements bound and endured to the benefit of Morocco, and that the Spanish rights as regards consular jurisdiction came to an end de jure as well as de facto. It is necessary to deal with another aspect of this question, which arises out of the wording of the declaration made by France and Spain on March 7, 1914. This declaration contained the following provisions. Taking into consideration the guarantees of judicial equality offered to foreigners by the French tribunals of the Protectorate, His Catholic Majesty's government renounces claiming for its consuls, its subjects, and its establishments in the French zone of the Sharifian Empire, all the rights and privileges arising out of the regime of the capitulations. So far as the government of the French Republic is concerned, it binds itself to renounce equally the rights and privileges existing in favor of its consuls, its subjects, and its establishments in the Spanish zone as soon as the Spanish tribunals are established in the said zone. The declaration whereby France complied with the above undertaking was made on November 7, 1914, and included the following paragraph. Taking into consideration the guarantees of judicial equality offered to foreigners by the Spanish tribunals and the Protectorate, the government of the French Republic hereby renounces claiming for its consuls, its subjects, and its establishments in the Spanish zone of the Sharifian Empire, all the rights and privileges arising out of the regime of the capitulations. I mean, it just got it. Wow. That's like that's a legislation saying that they have all the rights and privileges of the regime of the capitulations. But who is saying that? That's the declaration whereby France complied with the above. So it was France saying that, wait, hold on, let's read this again. Taking into consideration the guarantees of judicial equality offered to foreigners by the Spanish tribunals in the Protectorate, the government of the French Republic hereby renounces claiming for its consuls, its subjects, and its establishments in the Spanish zone of the Sharifian Empire, right? And we know that the Sharifian Empire is the Moroccan Empire, same thing. All the rights and privileges arising out of the regime of the capitulations. It will be observed that both declarations use the words renounce, a reclamaire, renonce, reclamaire, renounces claiming. And the question has arisen whether these words were intended as a surrender or renunciation of all the rights and privileges arising out of the capitulatory regime, or whether they must be considered as temporary undertakings not to claim those rights or privileges so long as the guarantees for judicial equality are maintained in the French zone by the tribunals of the protectorate, and so long as the corresponding guarantees are maintained in the Spanish zone. I mean, they just carved up the empire, didn't they? They got the French zone, they got the Spanish zone, they got the American zone. This is ridiculous. How does this happen? How do we let this happen? You know, we've been ruling for far too long. Time never was when man was not. That means we always been, you know, we always been ruling. We ain't been ruling for the past 250 years. That's like 2 days for how, in comparison to how long we've been ruling. The question is academic rather than practical. Even if the words in question should be construed as meaning a temporary undertaking, not to claim the rights and privileges, the fact remains that Spain in 1950, as a result of these undertakings, was not entitled to exercise consular jurisdiction in the French zone. It follows that the United States would be equally not entitled to exercise such jurisdiction in the French zone in the year 1950. This was taking place in between 1950 and 1952, this case. Nevertheless, it is necessary for the court to examine these declarations in order to determine what the parties had in mind when they used the words in question. The parties in both declarations used the expression, taking into consideration the guarantees of judicial equality. These are words which, if given their ordinary and natural meaning, state the consideration which led to the making of the surrender. But they are not words which would normally be used if it was intended to make a conditional surrender. The court is of opinion that the words renoncer à déclamer must be regarded as an out-and-out renunciation of the capitulatory rights and privileges. This view is confirmed by taking into account the declarations and other arrangements made by France with other interested powers designed to bring about the surrender of their jurisdictional and other extraterritorial rights in the French zone. The two declarations made by France and Spain in 1914 show that they both regarded the expression renoncer à réclamer as equivalent to a renunciation of the rights in question. In the Declaration of March 7, 1914, the French government bound itself to renounce equally the rights and privileges. In the later Declaration of November 7, 1914, France gave effect to this obligation by using the expression renoncer à réclamer. It is clear, therefore, that both France and Spain regarded this expression as proper for bringing about a complete surrender or renunciation of the rights and privileges in question. On July 31st, 1916, the French ambassador at Washington sent to the Secretary of State of the United States the text of the declaration signed with reference to the abrogation of capitulations in the French zone of Morocco by all the powers signatory of the Algiers Conference and by the South American republics. In the text thus transmitted, the expression used in English was relinquishes its claim to all the rights and privileges growing out of the capitulations regime. It is thus clear that at the date long before the present dispute had arisen, France regarded the expression relinquishes its claim, or in other words, renuncier reclamer, as bringing out the abrogation of the privileges in question. The declaration made by France and Spain of March 7, 1914, was one of a series of agreements negotiated by France with more than 20 foreign states for the surrender of their jurisdictional and other extraterritorial rights, so far as concerned the French zone of Morocco. At least 17 of these agreements used the expression renuncier reclamer as a means of bringing about a complete abrogation of all rights and privileges arising out of the regime of capitulations. They are referred to in the counter memorial in the following words: for the surrender of their jurisdiction, the jurisdictional and other extraterritorial rights. So all these people, I mean, all these states, they keep talking about renunciating and surrendering jurisdictional rights and extraterritorial rights. And again, for the renunciation of extraterritorial rights, further, all of the states which had signed these agreements abandoned forthwith the exercise of consular jurisdiction or other capitulatory rights or privileges in the French zone. In these circumstances, it is necessary to conclude that the Spanish Declaration of March 7, 1914, brought about the surrender or renunciation of all Spanish jurisdictional or other extraterritorial rights in the French zone, and an abrogation of those provisions of the Spanish Treaty of 1861, which concern the rights and privileges arising out of the regime of capitulations. The court, therefore, cannot accept the contention that the United States is entitled, by virtue of the most favored nation clauses, to invoke in respect of the French zone those provisions of the Spanish Treaty of 1861, which concern consular jurisdiction. The United States, they trying to invoke a treaty that they ain't got nothing to do with, which is the Spanish Treaty of 1861. But France tried to invoke the Treaty of Peace and Friendship, and they ain't got nothing to do with it. So y'all see, in other words, they're going back and forth using Moroccan laws to make their case. This is something else. While the Moors are just asleep. And again, because remember, this is 1952. Where were we in 1952? Segregated, KKK hangings and lynchings. Prophet had just passed away, what, 30 years prior? A lot happened in this country during those times, from like 1930 to like now, but really from 1930 to like the 60s. It's almost as if it was like a struggle. What was that? It's almost as if it was like a struggle. The United States was struggling, fighting two battles, right? Like they were fighting us, warring with us domestically, while also these international moves were taking place, treaties being signed, they're being taken to court. Obviously, in this one, they're being taken to court. But the battle that they was fighting with us was to do what? To keep us away from this information. That's what the whole thing is about. You know, all the lynchings, the civil rights movement, the Negro Black colored stuff, obviously the infiltration of the temple, clearly one of the major aspects of it. You know, they didn't have a comfortable reign. You know, they didn't have a comfortable.
Recording in progress.
They didn't have a comfortable. Their whole reign, you know, their time in which they had some authority and some power, it wasn't comfortable. They're constantly, because they were constantly worried about us. They were constantly worried about us, you know. We can't let them wake up. We can't, you know, whatever it takes, take a note. The oath of death. Make sure that these people not come to the light and learn about these treaties and learn about international law and get back to their governments. We got to keep them individualized as Negroes, Blacks, and colors. They cannot come back to their government seats. Because if they come back to their government seats, it's over for us. We signed the treaties. So we gotta keep it to where we can continue enforcing the treaties on them, while at the same time keeping them from being able to enforce their treaties on us. You see the trick bag? This is ridiculous. They spent the whole time with their foot on our necks, trying to make sure that we don't wake up and come to these treaties. So you got decolonization documents that came out all throughout the 50s, 60s. And African countries, Kibulon, they're all partaking in the movement, right? Forcing decolonization in their territories. You know, to the point where Gaddafi was gonna bring them all together as one state. You know, they had to off him for that. But while the African nations were battling for their sovereignty and independence, utilizing international law, the Moroccans, the Moors, the wealthiest people on the land were marching and praying, begging to not get hung, right? Begging for civil rights, not even human rights. We was out here begging and marching for civil rights. I mean, we wasn't even that wasn't the right argument. Like, we just been, so when they call us minorities, it's you know, it's in the mind. Minors, we're children, not we, but because the Moors of AMPAG, we competent Moors, we national, we majors, we are the majority. But we're coming out of that mindset though, or that status, with the rest of our people as minorities. And you hear Black people say that all the time about themselves. Oh, I'm a minority. I'm like, you don't hear that? Like, we've accepted everything that they have told us. It's like we force a simulation. We have amalgamated ourselves very well with that, to the point where we lost touch of who we are. We think we Americans. I mean, I used to think that too. I was banging that. We Aboriginal, Indigenous Americans. But at the same time, it's like, but this is Morocco though, because I always knew that. So it kind of didn't settle all the way well with me. That's why in hearing or seeing the truth about the difference in the jurisdictions and the two separate parties in these contracts, it makes that settles with me. It didn't feel right saying this whole American thing. It felt proud because everybody else was doing it. I was being in fellowship. The 1828 Webster's Dictionary, right? You know, or closer to the truth, I would say, at least, because we certainly didn't come from Africa. But we're Americans. We're the Aboriginal and Indigenous American. No, you're not Aboriginal and Indigenous American, nothing. We're Moroccans. Moors. Nationals, the Moorish people. Not Moroccan and American, taking both jurisdictions. I'm gonna leave the reading there. We stopped at 24. This one looks like it's getting very even more interesting because now they're talking about the Treaty of Madrid and all that. But we will leave that for next Wednesday. I foresee us having to go over this document for the next 2 weeks or so before it's complete. In some cases, I know that it's kind of a boring read to a degree, but you have to pay attention and see where it's going. It's going somewhere. So we just got to kind of like roll with it, pay attention to what's being said, because there's a story being told. It's a picture that's being painted. You just got to keep watching the movie, and we'll see what the storyline is at the end of the movie, right? So I'm gonna yield the floor now for any comments, questions, critiques, concerns.
Islam. I just want to give you gratitude for bringing this to the table and just doing this. This is very important, and it's not a boring read at all. And I think that we should definitely take our time with this so that we can fully ingest what we're reading so we can get a full understanding of this, because this is great foundational information, and it puts to rest any doubt or contradiction that this is indeed Morocco. So, I mean, I'm grateful for the lessons, and I want us to just continue on the pace that we're on, that we can understand it.
Yeah, Islam, brother, gratitude, and we're gonna continue doing that. We need the erudition. We need to understand that what we're doing is the correct thing. We're doing the correct things, and we are going to get to where we need to get. And where is that? Economic liberty without any inequality, officially ending colonization, at least in our territory of AMPAG, as outlined in our Constitution through the longitude and latitude of our uti pasadeta's jurisdiction. And there's nothing that the Charter Colony State of nothing can do anything about. Sister Makara, you are here, and you're.
I know. I was asleep. I'm sorry. I was trying to get here on time, but anyway, I was reading this yesterday, some of it, and I heard what you were saying and the brother's comment just now. And my concern, I definitely have concern. My concern is because I see what we're trying to do out here. My concern is, even though this is clear cut, obviously, if you have any intelligence, you're going to see this. The ones who don't see it, though, not the average Negro, Black, American, colored person. I'm talking about the so-called conscious Moors.
Yeah.
Who have arguments against this, or arguments to where they think they can do it another way. It's amazing to me.
Yeah, yeah.
And it hurts my heart too.
Yeah. Yeah. Been there, done that. You know, with a lot of our Moors. And it's funny because they all respond the same way.
Yeah.
What is that response? I don't hear from them anymore. And I'm cool with it, whatever.
Yeah.
There's when you get up, when you go to change your brakes, there's only one way you can do it.
That's right. Yeah.
When you go to change your oil, there's only one way you can do it. I mean, I keep saying the same thing.
It's clearly the instructions. Yeah.
You got instructions. You can't just do whatever you want, but everyone have their right to self-determination, and you got to just let people do whatever they want to do. And we do what we're supposed to do. And what we're doing is based on, see the difference? Here's the difference. And this is where I challenge anybody. the instructions that we are that we're following, we have absolute reference points for those. So for example, if somebody says, well, where you get that information from? International law treaties. I can go read. It's free. Like the Golden Age of the Moors book is Amazon is now charging like $8,000 for that book when at one point it was like $20.
Is that right? You're kidding me.
No, I'm serious. Yeah, Amazon is selling it for like 8,000. There's another place that's selling it for like 700, and that's still crazy. But the point that I'm making is, Act of Algeciras, Treaty of Peace and Friendship, Treaty of Madrid, UN Charter, any of these treaty constructive agreements, pull up Google it, and it's free.
Yeah.
And it's where your salvation is.
Yep.
It's good to know about about your national identity as a Moor, but that's the first step before statehood. That's why the Prophet brought that as the first path. You can't go into statehood as a Negro.
Right. And once we go into statehood as a Moors, then you're creating the peace and the time to actually really indulge in our history.
Yeah, that's another point. Right. And yeah, because now we can get access to the items, books, etc., that's in the Vatican, right? In the Pentagon, and in all these basements all over the place.
And we would create time and leisure to really absorb those things because we would be collecting the revenue that we're supposed to be collecting.
Yeah, like some Moors, they want to basically, I don't want this house. The Europeans are in this house. They have dirtied up the house. The house is now nasty and they don't respect the rules. So I'm just gonna go build another house. Okay. I say, give me my house back. And before you leave, clean it up. Why reinvent the wheel? Why go establish an agricultural department when it already exists? What we're supposed to do is take it over and govern over them. Study session 70 came out, finally, 70 and 71. And he touches on that. He talks about why reinvent the wheel. Instead, we can just govern the wheel. Duh.
That's what I'm saying. Yeah, it's a much simpler, easier, more expedient,
It is, and it's already yours anyway.
Yeah.
The whole system we had already created. They came in, corrupted it after we fell asleep. Now that we're waking up, we got to take it back and clean it back up under love, truth, peace, freedom, and justice for the upliftment of fallen humanity. That's it. That's the key. That's the game.
And can you imagine if we have to make everything over from scratch, how long it would take us? That's why I mentioned the expediency of this. Gee.
Everyone got their right to self-determination, and others want to do things however they want to do it. So I'm cool with it. Whatever you want to do, I'm over here. I'm over here with it. I ain't got time for the confusion. Everybody doing whatever they want. All that does is cause confusion. No, when we don't have, we need one path. We can't have 3, 4, 5, 10 different paths.
That's right. And
one path. We need to get on one bus and ride to that one destination. Right.
And the rest of the world adheres to this, but you feel you don't have to. And even the ones that don't written down, they do in practice.
Right. So, what can you say? Nothing. Just keep it moving, keep rolling with those who got the eyes to see and the ears to hear. That's my focus. I ain't got time for anybody else. I don't even care. You know what I'm saying? I'm good either way.
Yeah.
I got my Moors, and I'm very proud of the officials and nationals in AMPAG.
Yeah, and we're working on it, and it's amazing to me how many so-called conscious Moors that I've known. And when you approach them with this, they're like, nah, I'll pass. Or no, I'm gonna do my own thing. I'm gonna do it a different way because I this word means this to me or whatever. They argue semantics and all whatever they want to argue. it's like, I just don't understand them. I just don't get it. And it breaks my heart, but continuing on.
That's all we can do. Yeah, yeah, but luckily though, they're not the end all be all. There's more to come into this movement. There's more that's gonna come, and this new set of Moors that's coming in, that's due to come. Be careful with them because they coming in right with time during the time of the new paradigm shift, which is dealing with international law and statehood. They're coming in right on time for that shift, and when they catch on, and then the generation down the line from that, when they start catching on, and this thing starts becoming a thing, all them same Moors are gonna end up wanting to, come back on and, get their mind. We all have the right to self course correct, right? You can course correct, and at some point you can come back around, but that bus is moving, and ain't no monkey gonna stop that show, and we're gonna keep building. So the good brother Akil, I'm not even sure if he's on. I sent him the link, but they have grown to about 5 people at this point, so they're basically ready. All they gotta do is, oath of allegiance, the ballots for their elections. They need to do their elections, and then the inauguration. Package all that up, send it to the United Nations, Secretary General, send it to the United States, Joe Biden, and send it to the governor of whatever territory you're in. Put it on the record, which is ratify, promulgate, deposit your constitution and the state of facts of your state with the United Nations, the United States, as well as the governor, the de facto governor of whatever chartered colony that where your jurisdiction is, and that's you have established your government. Now you have established or checked the box for integrity, sovereignty and independence. That's that first box. After that, it's integrity of domain. That represents your laws, your legislation. We got quite a few coming real soon. Our website is up too, by the way, Sister Makara. It's
Oh, excellent. Put it in, is it in the link?
No, I'll put it in the link. Somebody please put it in the chat. I'll put it in the chat.
Yeah. Thank you.
Yeah, we got our website up and running now. It's called Moxon. You can remember it. It's ampagmoxon.org.
Oh, okay. All right. I can remember that.
Yeah. If because you already know Moxon.
Yeah, I already know that.
It's in there. Excuse me. And it was done by one of our nationals, Hakeem Bey. Brilliant brother.
Right. Well, we're keeping him in mind when we do ours.
Definitely. And I'm hoping that you guys come online pretty soon. So, yep, we got some things going, some good things cooking. I don't want you to hog the conversation. Who else? Has anybody else got something? Because if ain't nobody else got something, then you can hog it, Sister Makara.
Say that again.
Islam.
Greetings.
I'm
sitting back.
Your
I
phone
finally got it.
Your
Got
phone
on
is kind of messed up. Okay, go ahead. I'm sorry. Go ahead. I'm sorry. I was saying
Okay.
the phone sounded messed up, but go ahead.
Can you hear me now?
Yes, sir, I can.
Can you hear me?
Yes, we can hear you.
All right, yes. I've just been searching around. I've been searching around for quite a while now, trying to understand and get a little more understanding about our heritage and our birthrights. And like y'all said, it's a lot of misleading Moors out here that's not teaching or not showing laws and having things of concrete of nature to point out, what's really going on, like it's going on here with y'all. Y'all reading from things that's been established. You know what I mean? That's what I've been searching for. You understand?
Yes, sir.
I'm kind of new to it, but I'm at it at both hands and feet, trying to get it all and get an understanding of how it all works, you know. And I appreciate y'all, you brother, for reading this thing out, and sometimes from people hearing someone else reading, they can get a better understanding than themselves reading it. Okay,
Yeah.
so it's real it's real an eye opener and really heartwarming. And I want to thank Brother Jay for
Absolutely.
giving me the information that I need to get started with through this website. And I'm here tonight, and I'm enjoying it.
Islam, good brother.
I yield the floor. I yield the floor.
Yes, sir. It's fascinating how much information has been kept from us. And this has been over a period of basically 100 years, ever since the assassination of Prophet Noble Ali. That's what a lot of Moors ain't really understanding. I don't know what's going on with this indoctrination, man, but it is what it is. Not everybody is subject to it, but we have been blocked over for years. This ain't new. The Act of Algeciras came out in 1906. Why is it 2022 before we're finally hearing about this, man? And
Because the information was kept from us, like you said.
Right. These are the things that were supposed to be discussed in the temples. We were supposed to be talking treaties and international law,
And they went religious.
They went religious. But it was due to the infiltration. They ransacked his office, the Prophet's office. They ran up in there, ransacked it, removed literature, information. So if something was removed, then it had to be replaced with something, right?
And in the temples through them confiscating and changing information and putting it out, they're the ones that were putting out Moorish American.
Yeah.
They were putting it out hard and heavy through the temples.
And yeah, the temple is where a lot of the misinformation concepts
Yeah.
come.
Yeah.
And that's funny because that's the thing. Like Moors know this. Moors know that the temple has been compromised. Moors would sit there and tell me to my face. I'm talking about temple Moors. They'll say it to my face and then be like, then in the same breath turn around and behave as though someone came in and cleaned it up and it's no longer like it's the 1913 through 1928 temple when the Prophet was running things. No.
And they can tell the difference between what he said was real and what was the corruption. And like they know the difference.
Well, you are a citizen of the United States of America. That was added on later.
Yes.
The fonts
Hot and heavy right now. Temples are still pushing that on the back of the temple cards.
the what you call it? The fonts don't even match. You know, it's been a lot. It's been a lot. I mean, you know, part and parcel versus part and partial. You find a document that says one, and then you find the other document that says the other.
Yep.
I mean, it's clearly infiltrated and compromised. So which part of the literature are you working with?
Not to mention the temples deal a lot with their statutes and codes.
Yeah, that's all they deal with. They only deal with enforce the Constitution, statutes, codes. They don't deal with international law. That's the point.
No, not at all.
National law, statehood. And we, you know, the temples also think that they also think that the temple is a state, and it's not.
Yeah, they do. They do.
Article 5. Article 5. That's all I got to say. I mean, not Article 5, Act 5. This organization. That's how it starts off.
Yes. A lot of people, just like when Resolution 75 went over everybody's heads.
Of course it did. Went over my head.
With me too.
Went over everybody's head, but And then also too, the temple has members, not citizens or nationals. So
Yeah, yeah. And once you realize it though, once you see the corruption and wake up, like we have, all the people here have seen the lie and see the truth. So many more still don't see the truth.
well, it ain't meant for them to see the truth, obviously. So
Yeah, a lot of them in it for self-gain, that's why.
a lot of them are in, well, those are the leader guys within the movement, you know, not you know, there's it's divided into two different people, the followers and the leader guys.
Mhm.
The leader guys are the ones who's got something to gain from the misinformation that they're pushing.
Yes,
And
yes.
the followers, they're the ones who are getting
Mhm.
and who are experiencing the injuries that's being imposed upon them by these dirty Moors out here.
Mhm.
These paper terrorist Moors that like to sell nationality paperwork and all these documents for thousands of dollars or whatever. Give me so you're gonna give this guy $5,000 to get out of your foreclosure situation, but your foreclosure situation would have been settled with $2,500. Why are you giving him 5,000 when you can just settle the matter for 2,500, which is the cost of your mortgage in the first place? I don't know how Lamont Ale get away with this stuff, but he does. And he's not even a consular. That's not consular court. That's a standalone court. It's amazing.
He don't have he says he's a council.
It's amazing.
Councilor court, yeah.
And self-appointed, you know.
Yeah, self-appointed.
And the consul general is not who heads the. That's the other point. The consul general is not even the office that heads consular court. It's the chief judge. It's the Kazi. Through the the judicial branch. The consul general comes after. The consul general is like the attorney general of a state. It's the chief judge, the Kazi, who operates consular court, not consul general.
And again, if the instructions, they know that because it's in the instructions.
Not only is it in the instructions, but the prophet left the Europeans here long enough to teach us government. So the Supreme Court is not operated or ran by the Attorney General, is it? It's ran by the Supreme Court judge.
But the blessing in all of this, even with the blinded Moors, the leader guys, and all of that, is that the prophet said he's going to leave them here long enough to teach us government, and we're learning government right now.
And catching flack for it. But guess what? I don't give up. I was called a treaty Moor. I was by a brother on Facebook.
A treaty what?
A treaty Moor. So now I'm a treaty Moor.
That's good though.
He's a temple Moor and I'm a treaty Moor. Okay, I'm a treaty. I'm a Drew Ali Moor. I ain't no damn treaty.
Treaties are better than a temple Moor because treaties are
but the real point behind that though is the divisional term and labels. Why can't I just be a Moor? Why I gotta be a treaty Moor? You know, that was the point that I was raising.
Yeah.
And this was a grand sheet that keeps preaching, you got to learn to love instead of hate, but that's a hate type term because you're dividing us up. Why I got to be a treaty Moor? Why can't I just be a Moor? Well, it was a back and forth. Coleman knows about that back and forth. It was a little back and forth that took place on Facebook. And the brother, we all know the brother. I'm not going to call his name. I'll tell you about it after off the call. You know who it is. And it's just like, you're a grand sheet though, preaching this love instead of hate thing, but you're hitting me with this treaty Moor stuff as if, it comes off like hate and frustration because I won't succumb to the old temple ideology and old, mindset of Allah runs the government and the government is being ran by Allah. And I'm like, okay, well, what has happened in the past 100, what has Allah done in the past 100 years? See, it's
That's right. That's right.
the same
right.
Christian mindset, just, you know,
Mhm.
just basically switched over into an Islamic mindset that's based on the Christian mindset, which is based
That's
in
right.
dogma. It's a
That's
dogmatic
right.
mindset, basically.
Right. That's right.
And you know, Allah is arm, leg, arm, head, man, you know, man or woman in their higher self, just as well as the devil is the lower self. I mean,
Because it's in you. It's in each and every one of us.
Allah is arm, leg, arm, head. It's not some God in the sky floating around.
No, no.
That's the mindset that we share in Christianity as well as Islam, and they call it, but
That's right.
that's not the old time religion. Islamism is what we're supposed to be practicing, and that's the old time religion. And the old time religion has nothing to do with dogma. Old time religion is for the Muslim. Why am I saying that? Because the prophet said that more should study all prophets, Confucius, Buddha, Jesus. Why is that? Because all those people are us, and we wrote those scriptures. What he's saying is, don't be in fellowship and worship. Read all the books. Don't be, you know, a Muslim is not limited to one book, which would be like, let's say, the Bible or the Quran. You know, a Muslim studies the Bible, the Quran, the Holy Torah, all of them. We study them all. That's what a Muslim do. You know, that's the old time religion. It's a culture, and it's a culture of learning and studying and understanding, and
That's why we went to school for so long back then, and our organizations of learning were free, but you have the right character. If you didn't have the right character, you know that was a problem.
If anyone got something to say, just jump on in. We're just kind of like, you know, everybody else is kind of quiet, but if anyone else got something to say, just jump in. Don't even raise your hands, because I'm probably not going to be able to see you, because I can't see the whole screen. I'm sharing the screen, and it puts it into this little, I'll stop sharing the screen and just build. Okay. So yeah, but to get off the whole temple thing, you know, where we are in a different energy, in a different vibration in this day and age. This is the time that Prophet Noble Drew Ali was really talking about when he said that the Moors will come into their own in the year 2000. I'm not sure if he said in the year 2000 or in the 2000s, but it would be more correct to say in the 2000s. Clearly, the year 2000 is come and gone for the past 22 years. I mean, it's to the point where if you was born in the year 2000, you can drink. I mean, you'll be 22. That's been a long time. That's, you know, nothing happened in those last 22 years with Moors. It's happening now. Give thanks to the good brother J Bay for checking the boxes. For checking the boxes, that's the key. For checking the boxes and then teaching how to check those boxes.
Yes, I appreciate.
I appreciate that, and he's doing it for free. There's no charges. That's the main key. Birthright and nationality is free. That's the main, and it ain't. It's AMPAG as a whole that's doing this. Jay Bay just happened to be the master teacher in the classes, but it's an AMPAG effort.
AMPAG, yes, it's a group effort.
It's a group effort. And I would also go as far as to give credit. I still give credit to Abdullah Bey and Shem Malik Bey, because they're the only ones the only others who's out here teaching anything dealing with international law and statehood. The only problem with them, from as far as I'm concerned, is that they've never checked the boxes, you know. Which is cool, you know. At least you're teaching.
They were in that process, and then there was a what do you call a schism.
They did what with a schism?
They were in the process of checking the boxes, and then within their organization and structure, there was an issue. There was a schism. There was a.
I hear you. I hear you.
Yeah.
Well, I mean, you don't stop. You keep going. AMPAG had a schism. We had a dark storm. We had a storm in this joint, and we kept going. You know, you don't stop because you had you keep going. That's called perseverance. You don't just give up at the first sign of adversity, man. You know, I understand what the schism is, but they were supposed to have been checked the boxes long before that. But again, it's all good. They ain't got nothing to do with us. I'm just giving credit where credit is due, and regardless of what may have happened in the past, even between us, he still teaches international law and statehood. I don't necessarily have to agree with everything, but I can also give credit, and because nobody else other than those brothers that I just mentioned, I don't know of anyone else who's teaching this. There is nobody else teaching this other than Caucasians, Mock Law. There's a YouTube channel. He's like a professor of some sort. He's a Caucasian brother. And he teaches, he got some really great points. You ought to check him out. Mock Law, spelled MOOCLAW, Mock Law. 15-minute videos, 10-minute videos. They're quick videos going over specific points. That's how I learned about uti possidetis juris. He speaks on that, on many different things, just cogents, erga omnes principles, all different types of international law principles. You'll find it with that guy. But outside of that, as it relates to Moors and Moroccans and us trying to regain our sovereignty and reclaim the state, nobody else ain't talking about enacting laws and legislation and putting governments together and constitutions and ratifying, depositing and propagating. Nobody ain't talking about this stuff. So and even worse so, no one has checked those boxes. But AMPAG and New Mecca. So I got to give them shout outs. I will always give them shout outs. I will always give them their flowers. I don't think that AMPAG would exist without AMPAG and their assistance, not just in the study sessions, but even the ongoing assistance after the state government was established, especially as it relates to consular court and judicial order documents. That's not something that we're used to. Moors are used to writing writs and affidavits. Moors are not used to writing judicial orders, judgments, and opinions. That's boy, look, let me tell you something. That's far from our minds. Because it deals with international law and utilizing treaty provisions as the basis for the documents. Whereas writing writs and affidavits and such, they use municipal laws, statutes, and codes as the basis for those documents. That's a major difference in the two. So anyway, it's 9:30. Does anyone have any other questions, concerns, comments, anything else anyone else want to say? Before we wrap it up.
I would just get me on board. I want to get on board with all of it.
Who's that? My brother Frank?
Every bit of it. I want to learn all I can. That's right. That's right. That's right. I want to get my card. I want to do it all, my brother. Y'all just keep in touch with me and let me know what I need to do. And I try to share what I learn or what I read with others. But like you said, if you never heard anything like this or anybody ever spoken, a lot of people want facts. You know what I mean? They want to see something in writing, and that's with me. I was asking questions. Well, just go study this, go study that. But it's no one. There's been a few to tell me about go practice or go look at certain things about certain laws and stuff like that. But I'm learning it's more about international laws more so than anything else. You know what I mean? And reclaiming our birthrights. That's one of the most important things. And that's my goal is to reclaim my birthright. I got a 8-year-old and I want to try to well, you're 9 then, son. He corrected me on that, didn't he? And,
what area are
teach
you
my
in?
family. I'm in Southeast Georgia, somewhere, like you ever heard of Hinesville,
Okay.
Savannah?
All right. So you're in good hands already.
Excuse me?
You're in good hands already.
Yes.
Okay.
Yes. The person you're talking to there, Sisters Makara, she's out of the Texas territory. What she's saying is that you are in good hands because you're in the AMPAG territory, which is here in Georgia. So you are in good hands with brother. She's not lying to
Okay.
you. Sister Story will be in touch with you. She's not on right now, but she'll be in touch with you soon. Because you say you've already completed the application, correct?
Correct.
Is that right, brother? You say you
I think I sent you the, yes, I've completed the application. The only thing that wouldn't let me take a picture, because every time I took a picture of my ID, it would go back to the beginning every time with me. I don't know why, but you know, that's anything else it went on through with.
okay?
You know?
Well, don't worry about that. We'll take care of that. You got the application done, so she'll be in touch with you and give you any other alternate ways to submit the state ID. Your your driver's license.
Right.
And
Okay.
we'll,
I can take a picture of it. Send in a message or something like that. You know, if that would help.
whatever she said, we'll be in touch and
Right.
you guys can figure it out together.
Right. I was been concerned about capitalism, right? And on your birth certificate, or it's not like that on the with my certificate of live birth. And you know, out of curiosity, I called the county hospital where I was born, and it's strange. The receptionist told me once they after 10 years they destroy all that information, and that kind of puzzles me there.
Oh wow!
You know,
I've heard.
Uh,
I have heard of such a thing, but you know, that's where our national trust for our state comes into place. Comes into play, because all your assets will go into the national trust. The national trust serves as a shell company to interface with other corporations, right? Because a natural breathing human being cannot interface with a corporation. That's why that's why as a people we've been turned into artificial persons, so that commerce could take place properly. You know, everything has got to be in like manner. So in order for us as nationals, see, when you become a national of AMPAG, that means that you have been brought from the cares of the world or the waters onto the sea onto land, the rock of salvation, right? Which means now you have basically saying that you went from a dead corpse to now a living, breathing person, right? So now when you become a living, breathing, somebody needs to mute their mic or something. I don't know. Somebody got a really bad. Maybe it's you, Frank. In fact, it is you.
what's that now?
I think your phone is doing something really weird. I don't know. Okay. I'll just work with it.
My phone?
Yeah. There's a static.
Off.
There's a static thing going on. But
okay, you know, my brother, I was talking to someone the other night, right? And when I was talking to him, it did that. So I don't know if someone trying to infiltrate my phone or information or something like that. I don't know. But
it's clear now, so you're good. You're good.
Yeah.
It's clear now. But what I was saying is that, and so you become a natural breathing human being, and that being the case, you can't interface properly with the United States or its several corporations. So the National Trust does that on your behalf through the trustee, right? And so the National Trust is what will, and also for you as an individual, it would be your artificial person, which would be whatever your birth name is that's on the birth certificate. That would be the shell company for you as a human breathing, sentient being, a natural born human being. You know, you would have your artificial person as your shell company to interface with other corporations. You'll sign on behalf of that. I don't know what that is.
I can't hear.
It was every time I talk, I hear it. It's crazy. It's but anyway,
Is it an echo?
It's not an echo, it's a I don't know what it is.
Oh, wow.
Some robotic
Yeah,
thing.
yeah.
It's annoying, but I work with it. It's some FBI type work. I know.
Mm.
There's been an attempt to infiltrate us and we got rid of that cancer. But anyhow, so that's the game. You know, you want to have, we've got the National Trust that would protect your assets. And through the National Trust, the National Trust interfaces with other corporations on behalf of the state, and your artificial person strawman name interfaces with other corporations on behalf of you, the living and breathing person, if that makes any sense. So that's how we got it set up. We've got some things working really well over here with AMPAG. Good brother, you're in good hands. Just be patient and be patient with us as we continue checking these boxes all the way into economic liberty without any inequality. And it's coming. It will come. They will pay their share tax. Islam.
All right. Islam. Thank you, my brother.
You're very welcome.
All right, I'm gonna close out for the night, and I'll see y'all Sunday.
Yes, sir. Sunday at 7:30. I got to decide what treaty we're gonna go over. I haven't decided it yet. Anyone that has any suggestions throughout the week, you can text me or actually put it in the Telegram chat, and we can go from there. So
what you was reading tonight? What you was reading tonight? I started reading a little bit today.
Oh, okay.
Yeah, I read some of that today. Yeah.
It's fine. Yeah.
Hey, turn that down.
That's
Peace on, my brother. Peace.
Peace and love, good brother. You have a good one. I appreciate you, good brother. You have a good one.
Yes, sir, my brother.
Peace and love.
Peace.
So he's a new national coming on board, you all. I forgot to ask him to state his appellation, his free appellation. But yeah, so the good brother, as of now, is Frank Platt.
I was just fit to hang.
Okay.
I was just fit to turn to leave, but it's Albert King Bay. Albert King Bay.
King Bay, okay. Albert King Bay.
Albert.
Put that in the chat. Put it in the chat. Write it in the chat.
Yes.
Write it in the chat so we can be able to fucking read it out.
I'll try. Like I say, I'm new to this. I'm new to all this, man.
I understand, brother.
I'm new to. Hey, I'm learning as I go with this, my brothers, sisters. And I make trials and errors, and I don't have anyone here over my shoulder say, hey, nah, you got to stop, you got to go back and do this. So I have to make errors and come back and try to correct it. When I can't correct it, then I have to go outside the house and get somebody to help me with it, like the library or somewhere, you know what I mean? But I haven't stopped, you know what I mean? I never owned a computer a laptop about 2 years ago. I never had any Wi-Fi and all this kind of stuff, man. So, you know, hey, I feel that, I know that it's necessary and it's benefiting me to educate myself. And that's basically what I've been doing for myself in the last 10 years is starting from scratch and teaching myself and learning all I can in multiple areas, you know. And by the grace of Almighty, I am accomplishing something, you know.
Yes.
And I've been woken up, you know what I'm saying? I'm waking up to a lot of things, you know, and I see it. And it hurts me to my heart to, you know, I don't have the full ability to address these things on hand. So that's why I work so hard to try and learn and earn these things so that I can apply them when it need to be applied. Because these devils out here, they don't care, man. They don't care at all. You know what I mean?
Yeah.
And they will lead you and mislead you. You know what I mean? But I feel like I'm gonna overcome as long as I keep applying myself to the things that's in truth. You know what I mean? Therefore, I can live in peace.
Sure.
All right.
That's for sure.
All right, my brother.
It's not good, brother. I appreciate all this.
My granddaughter, baby.
I appreciate all this.
You know how to put something in the chat here? I'm see if I get my granddaughter here to put something in the chat, put my name in the chat.
Okay. All
Yeah, okay, yeah.
right, good brother.
Hey man, don't laugh at me, man.
I ain't laughing at you. I'm laughing with you.
Oh man. Okay, then that's good.
Islam.
Hey, I'm doing better. I'm doing better than most.
I would say so, yes.
You know,
Islam. No
others-
problem, no doubt, you know.
Others sit around and take what I tell them and try to reverse it and
Something happened with your
when I
phone.
tell them where to go and look for it, they don't want to do it.
Right. Yeah, I know, exactly.
You got it, man.
You gotta have a
Y'all get
mind
it?
of,
You got it in, my brother?
yeah. Okay, I got you. I see it. Abia
I done told you
Akeem
to turn
Bey.
it down.
I got you.
You got-
Abia Akeem Bey.
All right.
Okay, got it. Abia Akeem Bey.
All right.
Got it.
All right, my brother.
Islam, good brother. I appreciate it, man. Thank you so much.
All right.
And Sister Story, we'll be in touch with you, okay? All right.
Islam.
All right.
Peace.
Peace and love, good brother. So that's Abia Akeem Bey, Abia Akimbey, Abia Akeem Bey. So he's a new national coming in. Just filled out the application today. So we're growing and growing every other day. And thanks to the good brother Hakeem, that website is probably going to bring more people. And when we start putting our legislation on the website, it's probably going to get even worse. Especially that Plant Medicine Act that Shlomo came up with. Yeah, that's going to bring a lot of people. Anyway, with that said, if there's no other comments or concerns, Sister Makara, you got something you want to speak on? Or anybody else for that matter? All right. If you're speaking, Sister Makara, I can't hear you because I'm surprised you got quiet.
No, I'm sorry. I had to leave the room for a minute and
Yeah, exactly. I knew it was
well, I had to do what I had to do.
Oh, I knew it was something.
Oh, cause I'm so vocal.
Yeah, like just like me, I'm the same way. So I totally understand. But I was asking if you had anything else that you may want to share before I close out.
No, hopefully next time we share, we'll be talking about Texas is on the map. The Mentis is on the map.
Islam. That's what I want to see. And well, when you get a chance, get me your phone number. Send it. Have Coleman give me your phone number.
All right, no problem.
Because I don't have your phone number, and I want to be able to send you these links directly. But also,
All right.
you can gain access to the link probably through our website. Hakeem, let me ask you on the event section, do we have is the Zoom link put on? Is it available on those event sections?
Yeah,
Okay.
in the events, just click join event.
Mm-hmm. Okay.
And the Zoom link is attached to that.
Okay. Islam. Brilliant brother. So this is the guy who's gonna hook up your what do you call it, website and everything whenever
All
you
right.
get ready, okay?
All right.
He's a hell of a talent. So
Awesome.
so get with Coleman and have him give me your phone number. But going forward, you just access our website in the events tabs, and you'll see where you'll see the date, the scheduled classes. And in that, when you click on it, it'll give you access to the Zoom link and link you directly to the class. Okay.
Okay. Awesome. Thank you.
We'll pass that on to Basharai and Noble and whoever else who might be interested. All right.
All right. We'll do.
All right. Well, with that said, if there's nothing else, peace, love, and light to all of humanity. Sunday at 7:30, we'll be going over a treaty, like I said earlier. Not sure which one, but we'll know by Sunday.
All right. All right. Peace.
Peace and love, everybody.
Islam.
Islam.